Okay, welcome everyone. Thank you for joining us for today's webinar, Planning for a Client Whose Capacity is Diminishing. Today we have Harry Margolis and Alana Abramson to go over the complexities of estate planning for individuals experiencing diminished capacity and what to do about it. My name is Beth Cohen-King and I'm the Marketing Director at Margolis Bloom D'Agostino. I'm sure some of you have been on our webinars before, but just to reiterate, we have a panel on the side where you can type in questions as they come up. We will get to the questions at the end. And if for some reason you need to jump off, please don't worry. We are recording the presentation. And with that, I will let Alana take over. Thank you.
Great, thank you. Hi, everybody. As Beth said, this is a webinar called Planning for a Client Whose Capacity is Diminishing. And to begin, so the goals of this really are to help clients carry out their wishes and also protect clients from undue influence and exploitation. These are two goals that attorneys really keep in mind when working and when drafting estate planning instruments. And it's also evidenced by this quote that says that the lawyer generally should not prepare a will, trust agreement, or other dispositive instrument for a client whom the lawyer reasonably believes lacks the requisite capacity. On the other hand, because of the importance of testamentary freedom, the lawyer may properly assist clients whose testamentary capacity appears to be borderline. In any such case, the lawyer should take steps to preserve evidence regarding the client's testamentary capacity. So again, this quote really highlights the two goals that attorneys keep in mind when drafting documents. And again, to further reiterate, a case had quoted this responsibility as well, and the legal obligations and ethical obligations of attorneys. And it says that an attorney owes to a client or a potential client for whom the drafting of a will is contemplated a duty to be reasonably alert to indications that the client is incompetent or subject to undue influence, and where indicated, to make reasonable inquiry and a reasonable determination in that regard. An attorney should not prepare or process a will unless the attorney believes a testator is competent and free from undue influence. And again, this kind of goes back to the goals that we mentioned at the very beginning about making sure that we can try to help clients carry out their wishes while also protecting them from undue influence. And this is further explained by the rules of professional conduct that govern attorneys' professional ethics. And this specifically says that when a client's capacity to make adequately considered decisions in connection with the representation is diminished, whether because of minority, mental impairment, or for some other reason, lawyers shall, as far as reasonably possible, maintain a normal client-lawyer relationship with the client. So it's important to try to maintain that relationship, work with the client, try to be able to carry out their wishes and what they'd like to have the plan be. However, you have to keep in mind their capacity and what that might look like, and whether that could impact the ability to actually execute the documents. And the rule actually goes on to say that when the lawyer reasonably believes that the client has diminished capacity that prevents the client from making an adequately considered decision regarding a specific issue that's part of the representation is at risk at substantial physical, financial, or other harm unless action is taken and cannot adequately act in the client's own interest, the lawyer may take reasonably necessary protective action in connection with the representation, including consulting with individuals or entities that have the ability to take action to protect the client, and in appropriate cases, seeking the appointment of a guardian ad litem, conservator, or guardian. So again, it's important for attorneys to keep in mind the issue of capacity and whether there are any sort of protective actions that could be taken in order to safeguard the client and the ability to try to have them carry out their wishes. And again, kind of keeping these goals in mind, going back to the very beginning of carrying out their wishes and protecting clients from undue influence and exploitation, we have to dive deeper a little bit into incapacity and undue influence, because they are different, but they are related. And let's first start with incapacity. So incapacity is not a straightforward concept, and there aren't clear definitions really. And it can vary from situation to situation and from document to document. And what we mean by that, we'll get into that in a moment, is that with documents, that could depend on what document a client is executing, whether it's a will or power of attorney or something like that. The capacity standards could change. And situation to situation, again, we'll get further into it, but that can depend on what the client is doing. Who are they giving their assets to? Are they giving it to their spouse, or are they giving it to someone that they just met recently? And whether whether that requires a different level of determining their capacity. And so going to what we talked about, what I mentioned with the different capacity standards, this is the standard regarding the document of a will. So with testamentary capacity, it requires the ability on the part of the testator, the person signing the will, to understand and carry in mind in a general way the nature and situation of his property and his relations to those persons who would naturally have some claim to his remembrance. So that is the standard with signing a will. And when working with a client who is executing a will, to kind of gauge their capacity, ask questions about that, about their property, if they have an idea of their assets and their family members and things like that. That can be a way to gauge their capacity. Another standard of capacity is contractual, and this is a bit different than the testamentary one. So for contractual situations, the competence to enter into a contract presupposes something more than transient surge of lucidity. It involves not merely comprehension of what is going on, but an ability to comprehend the nature and quality of the consequences. From a testator, someone who is signing a will, we ask awareness of the natural objects of bounty. The choice among those objects may be seen by others as arbitrary, but arbitrariness or capriciousness may be allowed a donor. In the act of entering into a contract, there are reciprocal obligations, and it's appropriate when mental incapacity, as here, is manifest to require a baseline of reasonableness. So again, with contractual capacity, or with someone entering into a contract, it might require a little bit more of an understanding of the consequences of what they're doing. And it is possible that this kind of level of capacity might be required for a power of attorney. It's not entirely clear, but it's possible that that could be considered. The standard could be closer to this contractual standard than the testamentary standard. And again, with capacity, it can also vary from situation to situation, like I mentioned before. And so in a situation where a client plans on giving their assets to their spouse or their 3 children in equal shares, that's a little bit more traditional and typical. And so there might be less of a demand on their capacity, and it might be more acceptable and expected for them to kind of do that. But if a client were to all of a sudden want to give their estate to a neighbor or a new girlfriend or someone they've only been working with for a few months, that might kind of raise some red flags and make you really want to consider their capacity. And do they have capacity to make this decision? And do they understand what they're doing? And might just require some additional considerations and thoughts. And that then gets into not just are you looking at capacity and their level of capacity with entering into these documents, but you're also considering undue influence. And undue influence has 4 elements as outlined in this slide. The 4 elements are that the estate plan involves an unnatural disposition of the estate, like we just talked about, by it going to a caretaker that they had just started working with, or a neighbor or someone who is not who would traditionally receive the estate. And then it's by a person who is susceptible to undue influence, and to the advantage of someone who has the opportunity to exercise undue influence, who in fact uses that opportunity to procure the favorable disposition in the client's estate plan. So that is important to keep in mind with undue influence. And when considering all that we've said so far up to this point regarding the goals, again, with trying to help the clients with their wishes while also protecting them from undue influence, here are some things that we want to consider. We want to consider potential incapacity and the different ways to kind of look at that. Opportunity for undue influence. Does the capacity, is it just a capacity issue, or are there concerns of undue influence? Unusual distribution, as we talked about before, something a little bit less traditional as to who the individual is giving their assets to, might kind of raise an eyebrow. Haste, if a client all of a sudden, wants to execute documents really quickly without much of an understanding, then you kind of want to make sure they understand what they're doing. Disagreement, it could be disagreement among if the client and any children or spouse or anything like that, or an intermediary. Sometimes clients come in with a friend, maybe it's a new friend that hasn't really been involved before and is adamant about being in every meeting and speaking for the client. Then that might also raise a red flag as to whether the client is understanding what they're doing and is in agreement with what they're doing. This chart also further shows everything we've been talking about, that if there are more of those red flags that were on the previous slide, then you might want to have a little bit more caution as to their capacity and whether they have capacity or not. And so again, if there are fewer red flags, if it's someone who's giving to their spouse or their children equally, then you might not need to ask as many questions about their capacity, or there might be less of a concern in a sense. However, if there are more red flags as seen on the last slide, then you might want to have a little bit of your antenna up regarding their capacity. So that is kind of summarizing the goals that we've been talking about, those definitions. And I am now going to turn the PowerPoint over to Harry, who's going to chat about the last few slides.
Okay, great, Alana. Thank you very much. And just to kind of, I guess, summarize what you said, the lawyer has two goals, which are to some extent conflicting, because one goal is to carry out the client's wishes, and the other is to protect them from undue influence and also make sure they know what they're doing. They have capacity, and as Lana said, what's capacity may differ depending on what they're doing, whether it's a contract, a will, a trust, a power of attorney, a healthcare proxy. Each has different requirements for capacity, and a lot of this kind of gets sort of thrown into the mix. So if all the things that Alana listed as potential indicia of undue influence also are going to be things that are going to make us more hesitant to have a client sign documents or to prepare documents for the client. But there are a few things in this that are here in terms of best practices that can help ensure that we're not doing documents for somebody who is under undue influence or who lacks capacity. But it can't be foolproof, because we're often meeting with the client in our office, or now these days we may be meeting with them by Zoom, at least for one of the meetings, and it's a little hard to know what's going on outside of the Zoom session, what's on camera, or outside of the four walls of our office or conference room. So everything can seem like it's on the up and up, but we don't know what's going on out in the rest of the world. But there are a few things we can do to kind of give us a better chance of doing the right thing. So the first is meet with the client alone. So if there's any question at all, about what's going on, you definitely have to meet with the client by themselves. Next, when you are talking to them, ask don't ask yes or no questions, ask open-ended questions. So don't ask, do you want to give your estate to Joe? Ask, who do you want to give your estate to? So that they have to answer the question. And it's because it's so much easier if someone is lacking capacity, it's so much easier for them to just agree to whatever you suggest rather than to give you actual guidance. Spend as much time as you can with the client. Just the more time you spend with somebody, the better you're going to get to know them, know their situation, and know if it seems like they know what they're talking about and if they can carry on a good conversation. Meet with them at least twice. Don't get have a son or a neighbor or somebody say, my dad wants to do this with their estate plan. They want to appoint this person on their power of attorney. Don't then go with the prepared documents to meet with the dad when you only it's kind of too late or very difficult for people to change course at that point. And if things look a little unusual or strained, maybe make a home visit. So if the person has trouble coming to you, or if again you think they may be under undue influence because they're homebound, well, go to the home and see what's going on there. So why don't we go to the next slide? So just to reiterate, our duty is to do what we can to determine and help the client achieve their goals. And ultimately, if there's a question of whether a client had capacity, ultimately it's a judge that decides, not you. I mean, if it's very clear cut that they don't have capacity, then you're not supposed to go ahead. But if there's some question about that, and there's an argument that they know what they're doing, then the lawyer's duty is to go ahead and try to help the client carry out their wishes and preserve the evidence. So if someone wants to challenge it, the evidence, perhaps both ways, is there, and the court can ultimately decide whether they had capacity and the documents still stand. So we had a case, we were tangentially involved with a case which really represents what you're not supposed to do, but also about some of the pressures that can happen to estate planning attorneys. So there was an older woman who had a large estate, $10 million more or less, and this of course was some years back, so that was even worth more in today's dollars. She was in a hospital awaiting surgery, and she gets in touch with her financial planner and asks for help with her estate plan, because she realized she needs to have an estate plan. The financial planner calls an estate planning attorney who he knows and says, here's what's going on, time is of the essence, and can you help us? And the estate planner says, sure, why don't you talk to her and let me know what she wants. So he does. He talks to his client, reports back to the estate planning attorney, and part of what he reports back is that the client wants to give him, the financial planner, $2 million of her $10 million estate. The attorney drafts the plan, goes to see the client with the documents all ready to sign. The client confirms her wishes, that this is what she wants, and the financial planner is in the room the whole time. They sign the documents, the woman dies, and then all hell breaks out because, of course, this didn't look good. A lot of people weren't getting as much of her estate as they thought they should get. Our firm actually got involved at one point because we were asked to consult for I think one of her brothers, if I remember correctly, who felt that if the will were disallowed, then he would take a large share of her estate under the rules of intestacy. And unfortunately for people supporting that client, as I said, we were only tangentially involved. Someone discovered a 1980 will by this woman that disinherited this brother. So ultimately, they got little or nothing. But it was a big mess, and there were a lot of big law firms in Boston that were involved in the litigation, depleting what ultimately went to the heirs. So why don't you move to the next slide? So there are a lot of things in this case that are really show kind of the opposite of best practices. So there's a potential of incapacity. We don't really know whether the woman was incapacitated because the estate planning attorney only met her this one time and only had the word of the financial planner to go on. So it may have been that this estate plan was exactly what she wanted, but it was hard to know. It could be that the financial planner suggested the $2 million. It could be that the woman suggested to giving him a lot more, and he talked her out of it. He certainly had the opportunity to influence her. There was, of course, an unusual distribution, giving $2 million to your financial planner. However close you are, that's unusual. Haste, that's an argument for doing your estate planning before you're going in for surgery. And the intermediary here was a real problem. So the estate planner really didn't know the woman, hadn't spent time with her. And of course, it was the haste that created that situation. I'm sure if it wasn't for the haste, the estate planner would have gone out to meet with a woman and had at least a couple meetings and done things the right way. So the question is, what should the lawyer have done? And they really were in a hard spot because of the pressure of time that the woman needed to do this before she went in for surgery, and the estate planner might not have had time to go out and see her and do the 2 visits because he had, of course, had his own life and practice and was probably busy. But I think that would certainly have been the best practice if he had gone to meet with her rather than delegating to the financial planner. And if he had met with her alone and then gone back to his office, drafted the estate plan and gone back, I think there would have been a very different result in terms of the litigation. So that's basically our presentation, but we're happy to entertain any questions if there are any. Beth.
All right, there we go. There are not any questions, actually. Give anybody a couple minutes. We're a couple seconds here to ask, but also if questions do come up afterwards, obviously feel free to email. Alana's info is right here, and we do have a recording of this. So, I think, let's see. Yes, we'll have a recording within a week. It's going to be available. As always, it'll be in our e-letter and also in the news and events section on our website, which is where you can find all of our past webinars that we host. So please always look there. Give me about a week to put it up, but yes, that's it. So with that, I think that's it. I appreciate you guys for doing this, and hope everybody enjoys the rest of their day. Thank you.
Thank you all. So long.
I think